Welcome back. It's time again to Ask an Attorney, and here with us is Marion. We're getting our questions this week from Facebook, but you can also submit your questions to us on our website. Thanks for being here with us, Mike.
Sure, glad to.
Well, our first question deals with someone yelling. The person asking says, is it right for someone to drive by your house and yell out vulgar words to you?
Well, in Texas, there's actually an offense of disorderly conduct. When somebody uses abusive, vulgar, profane language in a public place, it can constitute disorderly conduct, but there's another part to that, is the conduct and the words by their very utterance are supposed to have to incite a immediate breach of the peace. So it's more than just somebody using vulgar language. There's got to be a little bit more to it than that. However, if it's a constant thing that continues to happen, you may also be looking at a possibility of a harassment thing. You need to contact your law enforcement. And you may also contact an attorney because you might be eligible for either a protective order, a restraining order, or a peace bond to keep that person from coming around.
Okay. Our next question says, our single unmarried sister with no children passed away. She left behind a handwritten will witnessed by 2 people but not notarized or filed with the courthouse. Is the will sufficient in the eyes of the court?
It sounds like what this individual is talking about is what's referred to as a holographic will, meaning something that's written entirely in the deceased person's handwriting. And so most likely it's going to be a valid will as long as it's 100% in that person's handwriting. What they need to do is contact an attorney so they can take a look at that will and see if it meets the requirements, and then they can offer it for probate. And once somebody is appointed as an administrator over the estate, then they can handle all the affairs of the state just like it was a regular will done by a lawyer. One difference that you might have to do, though, is have to have a witness come testify that they recognize that handwriting and that is in fact that person's handwriting, so that it's not somebody else's.
All right, and our last question. I would like to know what the law is on informing parents of an aggravated sex offender attending public school. Shouldn't our children be protected? Well,
absolutely, our children need to be protected, and there's specific laws that govern when notification is supposed to take place and to whom. The Code of Criminal Procedure defines that in Chapter 62, where it talks about law enforcement has to notify the schools and the DA's office has to notify the schools. This person, since they're enrolled in school, I'm kind of assuming that they're possibly a juvenile. Now, there's some issues that we come up with when we deal with a juvenile is there are circumstances in which a juvenile may have their registration deferred, they may have their registration non-public, or they may be able to have it waived completely. So just because the person is on probation may not make them a registered sex offender. And the education code dictates that the school has to remove them from regular classrooms and evaluate them to see what the best placement for that student is.
All right, thank you, Mike. And of course, we answer your questions right here every Wednesday. You can submit them on our website, fox4beaumont.com.